Hey class, welcome to week 2 of administrative law. I hope the first week of your semester has gone as smoothly as possible given the circumstances. So this week we are going to talk about the American bureaucracy. All right, so let's get started on understanding the bureaucracy. One question that comes up a lot is, is bureaucracy good or bad? And in reality, it's neither. The bureaucratic system is the most effective way that we know for managing large organizations. So that could be the government, could be a business, any type of large organization. In our case for this class, when we talk about the American bureaucracy, we are talking about the non-elected government officials in the executive branch, as well as career civil servants who are apolitical or nonpartisan. So when we talk about the bureaucracy, some of them are political appointees, and some of them are the career, non-political people who do the day-to-day work that keep the government running. So the foundation of bureaucratic management, what we call public administration, is rules. And it's just not possible to write rules that foresee every possibility or every eventuality. So there are times when either the bureaucrat or an entity outside of the bureaucracy, such as Congress or the courts, has to intercede in order to reach the best decision. Now that said, a properly designed bureaucracy will have the flexibility to handle a wide variety of situations. And we're going to discuss that more when we cover the concept of agency discretion. Now, as you probably already know, it was German sociologist Max Weber who argued that the bureaucracy constitutes this most efficient and rational way to organize human activity and organize the systematic processes that are necessary to maintain order, maximize efficiency, and most importantly, eliminate favoritism in the bureaucracy. And that's part of why we've got civil service protections in place for our career bureaucrats. Now, on the other hand, Weber also saw unfettered bureaucracy as a threat to individual freedom. So it's got this potential of trapping individuals into this impersonal, what he called iron cage of rule-based rational control. In that type of system, civil servants are just cogs in a wheel. They've got no discretion. They've just got to carry out black and white mandates. And again, when we talk about agency discretion, we'll understand why that is not something that we want. All right, you'll recognize this slide from last week because, as I noted last week, government bureaucracy is not new. So while the word itself was coined in the mid-18th century, organized and consistent administrative systems of government existed much earlier. The first system that we know about is from around 3500 BCE in ancient Sumer, and that is where the development of writing and the use of documents, in that case clay tablets, not paper, those developments created a class of scribes. So these were our first historical bureaucrats, and they did things like administer the harvest. Like I said last week, Egypt, Persia, and Rome all had thriving bureaucracies long before that word bureaucracy was actually coined. So Rome originated the merit system, paid civil service, and other features of modern public administration. So the Roman Republic, before it became an empire, had two chief executives. They were known as consuls, and it had a number of other administrative officials. So it had people in charge of economic policy, the treasury, the 5-year census, and also law enforcement. Rome's city code also regulated many aspects of daily life. It had neighborhood zoning, water and wastewater, price controls on staple foods, and government subsidies for some of those foods. They even had restrictions on building heights and regulations of Rome's cooked food shops, which is basically the equivalent to our modern day restaurants. So government bureaucracies, even those that reach into our everyday lives, are nothing new. What is somewhat new from a historical perspective is how the bureaucracy functions within a democracy. There can be pure democracies, republics, and democratic republics. So the US is a democratic republic. We elect politicians to represent us rather than engaging in direct control of our government. However, our government's authority is limited by us, specifically by our individual civil liberties. And the government is accountable to us, its citizens, primarily through elections. Now, we do not elect our civil servants, nor do we elect the political heads of departments and agencies. So the bureaucracy itself is not really a democratic institution. But agencies are accountable to the people in some ways. So for instance, we elect the president, who then appoints those agency heads. And we elect our members of Congress, who hold the purse strings for those agencies. So while the US has a bureaucracy that's embedded in our democratic system, bureaucracies themselves are value neutral. They work equally well in authoritarian regimes as they do in democratic ones. Bureaucracy, it's just a method of managing a large organization. It's up to us, the people, to make sure that we are managing it in line with democratic values. And I've got this quote from Winston Churchill, who famously noted that democracy is not perfect, it is not all-wise or all-knowing, and in fact, it's the worst form of government there is, except for all the other forms of government. Let's talk a bit about the structure of our federal government so that we can understand where the bureaucracy fits in. So it was the Declaration of Independence that broke the American colonies away from England, but it's the US Constitution that is our true founding document. And the Constitution went into effect in March of 1789. And it famously begins with, "We the people." And that's important because it shows that the US government is in fact intended to be accountable to the people. It does not govern pursuant to some type of divine right, the way that kings did. It governs pursuant to the will of the people. It was truly intended to be a government of the people for the people. Now, the people meant something much different back in the 1700s. It mostly meant white landowning men. Historical documents, however, do indicate that the framers of the Constitution intended it to be a living document, not something that was stuck in the 1700s. Because we currently find ourselves in uncertain times, with legitimate concern over whether the US government is working for all Americans, and I don't just mean in terms of the botched federal response to the pandemic, but sort of systemically. I want to note up front that this class is focused on how the government, particularly our executive branch, is supposed to work. I've got a great deal of admiration for our constitutional system of government. As an attorney, I have specifically sworn to uphold the US Constitution. But my respect and admiration for our government and our Constitution doesn't mean that I think it's perfect. Ben Franklin was reported to have said that the Founding Fathers gave the people of America a republic, but only if we could keep it. And there's more to that story. Franklin knew that the first man to hold the presidency under the Constitution was a good one. That was George Washington. Franklin knew that Washington had the best interest of the country and people at heart. But he worried that nobody knows what type of person will come along afterwards to assume the presidency. And he voiced concern that in the newly formed United States, as in basically every part of the world, the executive would always try to increase power until it ended in a monarchy. And so these are really sobering words, so keep them in mind when we discuss agency authority. So while our course focuses on how our system of administration is supposed to work, it is absolutely crucial to recognize when and how our government has not worked for large numbers of Americans. And that includes how it presently does not work for large numbers of Americans. An examination of our nation's systemic inequalities and the history of how our bureaucracies at all levels of government have operated to discriminate against women, people of color, and other minorities is well beyond the scope of this course. I do, however, urge you to take the time to learn about how our institutions did and do discriminate. The best thing to do is to read several histories of the United States, starting in colonial times, preferably ones written by notable historians. There's no such thing as a totally unbiased history book, and so that's why I say read a few to get a better idea of how things really work. And history is important because the inequalities that we see today, those are the consequences of our history. And so we need to understand that history in order to make better choices moving forward. And as public administrators, you will have opportunities to make those better choices. All right, back to the regular lecture. Here we've got a chart that shows how the Constitution set up the structure of our federal government. We have three co-equal branches of government. They provide checks and balances on each other. At the most basic level, the legislative branch creates the law, the executive branch carries out the law, and the judicial branch interprets the law to make sure that the other two branches are not overstepping their authority. You can see here that I also have lists of agencies. And you can see that the majority of those agencies fall within the executive branch, although a handful do fall within the other two branches. What you don't see here are the states or Native American tribes, and I will cover that shortly. So the Constitution starts with its preamble, the We the People, and then it goes on to Article 1, which creates the legislative branch. Section 1 of Article 1 states very clearly that all legislative powers are vested in Congress and that Congress is bicameral. That means it's got two houses, the House and Senate. Section 8 explains the whole scope of legislative power granted to Congress. So the first clause in Section 8 notes that Congress must provide for the common defense and the general welfare. The Constitution grants those powers to Congress, and that is actually one of the reasons why, for instance, the president cannot unilaterally declare war, because Congress has a say in the common defense. Section 8 has other statements of congressional power, and that includes regulating commerce with foreign nations, among the states, and with Indian tribes. And this phrase about regulating commerce is important for two reasons. One, it sets up Congress's Commerce Clause power, which we'll discuss shortly, and two, it recognizes that the states and Indian tribes have their own sovereignty, because that clause puts them on equal footing with foreign nations. Section 9 of Article 1 contains some restrictions on congressional power, prohibiting Congress from, among other things, favoring one state over another, or creating laws that are applied retroactively, which we call ex post facto laws. Now, given that the U.S. Postal Service has been in the news so much lately, particularly due to the actions of the Postmaster General, who is an executive branch official, I want to point out that the Constitution vests the power and responsibilities of the Post Office with Congress, not the President. So in carrying out its power to establish post offices, Congress created the U.S. Postal Service in 1792, though Ben Franklin had actually been named Postmaster General back in 1775 before the U.S. even existed. So in 1792, we've got the Postal Service Act. It creates the Post Office Department. That became a cabinet-level department in 1872 through the Post Office Act. Then in 1970, the Postal Reorganization Act transformed the Post Office Department into the United States Postal Service that we know today, and it established the USPS as an independent agency. And back in 1970, Congress reiterated the nation's postal policy. Congress noted that the post office shall be operated as a basic and fundamental service provided to the people by the government. It's authorized by the Constitution, it's created by an act of Congress, and it's supported by the people. And Congress went on to say that the Postal Service, its basic function, is the obligation to provide postal services to bind the nation together. It is supposed to provide prompt, reliable, and efficient services in all areas of the country. And Congress also specifically said in 1970 that the costs of establishing and maintaining the Postal Service are not to be set up in such a way to impair its overall value of servicing the people. Congress specified that it intended the post office to provide a maximum degree of effective and regular postal service to all areas, rural, communities, small towns, places where post offices are not self-sustaining. Congress wanted effective postal services for all residents across the U.S., regardless of whether they were in urban or rural communities. Now, Article 2 of the Constitution creates the executive branch, and it vests all executive power, which is the power to carry out laws, to the president. The president is the commander-in-chief. He grants pardons, appoints ambassadors, and so on. Now, interestingly, Article 2 splits the appointment power of officers, or the president's appointment power, to officers and inferior officers. So we can surmise that the first reference is to superior officers. The Constitution calls them principal officers. So the president appoints those superior officers, but Congress, by statute, can vest the appointment of inferior officers elsewhere, including the heads of the departments, which is why you can have heads of executive departments appointing the agency heads in their subunits. Article 2 also sets forth the process of removing a president, impeachment, which is triggered if the president engages in what the Constitution calls high crimes and misdemeanors. And that charge, high crimes and misdemeanors, it was understood by the framers to cover really any type of allegation of misconduct. So it covers ordinary crimes, but also it covers abuses of authority that might not be criminal. And it does so on the grounds that we, the people, expect our elected officials to adhere to their oath of office. So while impeachment was all over the news earlier this year, for our purposes, the most important part of Article 2 is that it grants the president the power to appoint and oversee principal officers in the executive department. So that's an important point for administrative law because agency policies are generally set from the top. All right, then we've got the judicial branch, created by Article 3. The Supreme Court is the only court specifically created by the Constitution, but pursuant to Article 3, Congress can and has created other courts. So we've got our district courts and our courts of appeals, which are also called circuit courts. They were created by Congress, but they fall under the Supreme Court. And Article 3 sets forth the scope of the Supreme Court's authority. So the Supreme Court has ultimate say when it comes to cases that arise under the Constitution or federal laws. Additionally, it's got ultimate say in cases involving the U.S. as a party, cases involving ambassadors, admiralty, and maritime cases. The Constitution gives the Supreme Court both original and appellate jurisdiction. So that means that some cases can be filed directly with the Supreme Court. That's original jurisdiction, where the Supreme Court operates like a trial court. And others have to work their way up through the court system before the Supreme Court gets to hear the case. That's its appellate jurisdiction. And we will talk about that later when we examine the concept of judicial review as a method of holding agencies accountable to the public. All right, and then we've got the rest of the Constitution, Articles 4 through 7. Article 4 deals exclusively with the states. It contains our full faith and credit clause, which is basically an acknowledgement that every state must respect the laws and rulings of sister states. Article 5 provides the process by which we can amend the Constitution, and Article 6 very clearly states that the Constitution is the supreme law of the land, so it takes precedence over all other laws. Article 6 also requires government officials, be they elected, appointed, or part of the civil service, they have to take an oath or affirmation to support the Constitution. And importantly, Article 6 prohibits religious tests for office. Many of the framers were not a particularly religious bunch, at least not as we understand religion today, and they intentionally did not want to limit government service to any particular religious group. Then there is Article 7, which is just the process for ratifying the Constitution. After those 7 articles come the Bill of Rights, the first 10 amendments to the Constitution. During the Constitutional Convention, there was a pretty vigorous debate over whether or not these rights should have been included in the Constitution itself. And the framers compromised. And so the amendments, they've got the Constitution, and then the amendments that make up the Bill of Rights were proposed very shortly after the Constitution went into effect, the same year, and they were ratified within about 2 years. So federal and state agencies must comply with the Bill of Rights, and so we're going to discuss that later in the course, as it is very important for public administrators. So we currently have 27 ratified amendments to the Constitution. Congress has sent 33 amendments to the states that have only ratified 27. In addition to the 10 amendments that make up the Bill of Rights, we have another 7 amendments that operate to safeguard our civil rights. So these are amendments focused on liberty, individual rights, and notions of justice. Then there are also amendments that cover topics like governmental authority or governmental processes and procedures. So for example, the 18th Amendment prohibited the making, transporting, and selling of alcoholic beverages anywhere in the U.S., otherwise known as prohibition. And then fairly quickly thereafter, the 21st Amendment repealed the 18th Amendment, and it returned that authority to the states. So the states have the authority to regulate alcoholic beverages. Now, as you know, the Constitution doesn't mention agencies. It does, however, specifically mention executive departments in Article 2. So Article 2 states that the president may require written opinions of the principal officer in each of these executive departments upon any subject relating to the duties of their office. So clearly this indicates that the founders of our nation knew that there were going to be offices within the executive branch that report up to the president. Those executive departments are the primary agencies of federal government. The heads of those 15 executive departments are known as secretaries, for the most part, not Department of Justice, that's the Attorney General, and collectively they make up the president's cabinet. So the president appoints each secretary, who must be confirmed by the Senate. The president can remove secretaries at will, and so these secretaries tend to be, but are not always, political appointees who change along with a change of presidential administration. Now, each department is made up of many, many agencies and sub-agencies, all of which kind of report up the chain of command to the president. So the president is supposed to exercise authority and control over these agencies and sub-agencies. So just as an example, the Department of Commerce, that contains NIST, which is the National Institute for Standards and Technology. Also within Commerce is NOAA, the National Oceanic and Atmospheric Administration, and the National Weather Service, the Census Bureau, as well as the U.S. Patent and Trademark Office. And while it's called the Department of Commerce, it's actually prohibited from engaging in commerce. So what the Department of Commerce really does is serve as a major scientific and data repository for the U.S. government. There are also agencies within the executive office of the president. Importantly, that includes the Office of Management and Budget. And then there are independent agencies, including NASA, the CIA, and the EPA. These agencies are not represented in the cabinet. They are not part of the executive office of the president. But they do deal with many government operations, economy, and regulatory oversight, and we'll talk about those in just a bit. First, let's take a look at the structure of an executive department. I'm going to focus on the USDA for a moment, so you can see just how much an executive department does. So this is the USDA's org chart, and there's an internal USDA rule that limits the departments to 7 offices run by undersecretaries. So there can be plenty of subunits, but the USDA's got a secretary and then only 7 undersecretaries. So when the Trump administration first came into power, and it wanted to show that it was serious about foreign trade, so it split one of those boxes into 2 different boxes. So it wanted to have, farms, foreign agricultural services, and foreign trade. But this internal rule limits it to 7 undersecretaries. So the Trump administration had to get rid of an undersecretary, and the one to go was the Undersecretary for Rural Development, ironically, the part of the federal government that actually provides the most help to rural individuals within the U.S. So the administration moved the responsibilities that used to be delegated to the Undersecretary for Rural Development to a special assistant to the secretary. And it might seem beneficial to be located within the office of the secretary rather than in an office of an undersecretary. But in reality, assistants to the secretary have a lot less authority than undersecretaries. And those assistants are not directly accountable to Congress, so there is less oversight. So after the Trump administration got rid of the Undersecretary for Rural Development, 578 different organizations, businesses, and local governments signed a letter opposing the elimination of that rural development mission area and undersecretary. That didn't really matter to the Trump administration, but Congress did require the reestablishment of the Undersecretary for Rural Development in a farm bill. That is really good news for rural America. And that's because the Office of Rural Development helps communities develop and expand businesses. It helps create new economic opportunities. And really importantly, it helps with rural infrastructure. So housing, water, electric, telecom, all of that. So historically, the Undersecretary for Rural Development, and that office in general, is the most powerful advocate for rural Americans within our federal government. In any given year, it makes over $25 billion with a B, $25 billion in loans, guarantees, grants, and other types of financial assistance to 100,000, 200,000 individuals, businesses, nonprofits, as well as state and local governments. And since Congress reestablished the Undersecretary for Rural Development, the Trump administration is going to have to nominate an undersecretary. Towards the end of last year, the administration did swear in a deputy undersecretary, but as of this lecture, the undersecretary position itself remains unfilled. Now, of course, the president is not the only one with control over the USDA. Congress has passed many, many laws that set USDA policy and create USDA authority. This is a list from Wikipedia, which does a surprisingly good job when it comes to administrative law. So as a side note, feel free to use Wikipedia as a starting point in your research. Just don't cite to it. Go ahead and data mine that Wikipedia entry. Footnotes often will direct you to a variety of scholarly sources. In any event, based on these laws, the USDA issues regulations and it maintains a really wide variety of operations. If you haven't read the book, The Fifth Risk, I recommend it. It's a quick read. It's a great look at the inner workings of agencies, and it's also been called a love letter to the bureaucracy. So in that book, the author, Michael Lewis, interviewed many people, including those in leadership, senior executive service, and he interviewed them about what their agencies do. You know, how do they serve the public? And the point of the book was to make the American public, or help the American public, understand the importance of our bureaucracy. So at one point, Lewis describes a drinking game played by people who've worked in the USDA called Does the USDA Do It? So somebody names an odd function of government, say shooting fireworks at Canadian geese that are too close to airport runways, and then somebody else has to guess if the USDA does it. In the case of shooting fireworks at geese, yes, it does. Now, the USDA does, of course, provide assistance to farmers, but only a small fraction of its annual budget, which is massive, is actually spent on farmers. The USDA finances and manages tons of programs throughout America, including rural America, such as free lunches for kids who live, near the poverty line. The USDA is also responsible for the safety of the meat that we consume. The FDA is responsible for non-meat, so interestingly, cheese pizzas are the FDA's problem, but pepperoni pizzas are supervised by the USDA. Just one of the myriad of little tidbits of information about the inner workings of our government. So as you can see, though, from the slide, the name U.S. Department of Agriculture is somewhat misleading, sort of like the Department of Commerce. That name is misleading. You would think that the USDA focused only on agriculture. It does focus on agriculture, but it does a lot more. It runs 193 million acres of national forests and grasslands. Like I said, it's charged with inspecting meat that Americans eat. That includes around 9 billion birds a year, mostly chicken. It runs a massive science program. It runs a bank with over $200 billion in assets. That's part of what it uses to render assistance to rural America. It monitors catfish farms. It has a shooting range inside of its DC headquarters and an apiary on the roof of that headquarters to study bee colony collapse. The USDA also polices conflicts between people and animals, and it brings legal action against people who abuse animals. Like I said, it provides free lunch for kids near the poverty line. It runs SNAP, which we used to call food stamps. It provides a variety of assistance, related to disasters, from fighting avian flu to fighting wildfires. The USDA actually has a very large fleet of aircraft for firefighting. And it does more than just this, but I think now you've got a pretty good feel for the fact that the name of an agency does not necessarily cover everything the agency does for the public good. All right, I want to talk a little bit about our federalist system of government. By setting up a federal government while also recognizing the various state governments, our Constitution creates a federalist system. And federalism is the division of power between two, or in our case, more than two, sovereigns. So the Constitution sets forth the powers of the federal government as its own sovereign government, but the Constitution recognizes sovereign rights of state governments as well as the rights of the people. So there are three types of federalism. There is dual, hierarchical, and cooperative. In dual federalism, the federal and state governments, they're both sovereign. They have different, sometimes concurrent areas of jurisdiction. And in dual federalism, the federal government is limited to the powers that are enumerated in the Constitution. So if the Constitution grants the federal government a power, it has it. Everything else stays with the states or the people. In hierarchical federalism, the federal government is supreme, and the states only get the powers that are not claimed by the federal government. Dual federalism does still recognize the supremacy of federal laws over state laws, and hierarchical federalism still recognizes that the feds are not supposed to make a power grab at the expense of the states. There's also cooperative federalism, which is a close and collaborative relationship between the states and the feds for a common objective. Usually that's the administration of federal programs with assistance from the states, or the administration of state programs with grants from the government. So the US, we started out as a very dual federalist system. Over time, we have become more hierarchical, but these are not mutually exclusive. So even in our kind of hierarchical system that we have right now, we still engage in dual and cooperative federalism too. This is a rather intricate view of our federalist system from 1862. I think it's a pretty beautiful diagram. It shows the federal government and all of the states and how all governmental powers flow throughout the entirety of the American Union as it was in 1862. I will post this in our online classroom so that you can take a closer look if you're interested. Okay, as promised, let's talk about states and tribes. First, a little note on legal language. Although we use terms like Native Americans, First People, or Indigenous people, as we were having our normal conversations, the federal government's legal term for Indigenous people within the borders of the US is American Indian or just Indian. So outside of the legal context, I would not refer to North America's indigenous people as Indians, but in the legal world, it is the correct term to use. Okay, now remember, The Constitution, in the Commerce Clause, it recognizes foreign nations and Indian tribes in addition to the states. This means that the federal government recognizes the sovereignty of Indian tribes, the same way that it recognizes the sovereignty of state governments and foreign governments. And the reason for this is the historical manner in which the Europeans first interacted with Native Americans. And I don't mean first interacted in terms of wiping them out with disease. I'm talking more specifically about when they entered into treaties with Indian tribes. To Europeans who were arriving here in the Americas, they treated the tribes sort of as pre-existing governments, and they dealt with them on a government-to-government basis, the same way that, say, England would deal with France. That is a massive oversimplification, and it ignores many atrocities perpetrated against Native people, but I'm just trying to give you broad strokes here. After the American Revolution, the U.S. President, Congress, and the Supreme Court have repeatedly affirmed that tribal nations do retain powers of self-government. But that is not to say that the federal government has done a very good job at respecting those rights. Even on a benign and bureaucratic level, the federal government still asserts control over Native tribes according to various statutes, and it's got a whole host of regulations in the Code of Federal Regulations that covers, Indian tribes. So that's Title 25 of the CFR. There is no similar CFR title for states. The CFR defines the word state, defines it to include any of our states: DC, Puerto Rico, Virgin Islands, Guam, American Samoa, and the Northern Mariana Islands. That said, although there's no CFR title for states, the states are required to comply with various federal laws, and the federal government can require states to take certain actions. So for example, you can see on the lecture slide an excerpt from the Stafford Act, which requires states to implement certain roles and responsibilities in their emergency response and management plans. So the U.S. Constitution, it makes certain guarantees to the states and to the tribes as sovereign governments, but it also expects compliance with federal laws and regulations. All of our state governments and many tribal governments are set up similarly to the federal government. They've got a constitution and 3 co-equal branches. At the state level, the executive branch is headed by a governor. The legislative branch is either the General Assembly or the state legislature. And with the exception of Nebraska, all of our state legislatures are bicameral. They consist of 2 houses. Similarly to the federal government, they've got the judicial branch with several levels of state courts. It's actually in the state court system where we see the most difference between state governments. So New York, for example, has, in my opinion, a really convoluted court system where the trial courts are called Supreme Courts, whereas most states call their highest court the state Supreme Court. But that's the name that New York uses for its lowest court. And I guess I can't rag too much on New York because Maryland calls its highest court the Court of Appeals, even though, like all states, Maryland has a layer of appellate courts between the lower courts, trial courts, and the highest court. Tribal governments have a lot in common with state governments. They are also set up similarly with their executive branch headed by a governor, president, chief, or chair. They've got a legislative branch called the Tribal Council, and the judicial branch that consists of tribal courts. So both states and tribal governments have their own sovereign immunity. And technically, tribal governments are full nations within our nation, whereas states are not themselves nations. And so while states are sovereign, they have to comply with the U.S. Constitution and federal court cases that impact constitutional rights, and a whole bevy of other federal laws. That's not automatically the case for tribal governments. For the most part, there has to be a treaty or some other agreement in place in order for the feds to be able to force tribes to comply with federal law. And interestingly, Native Americans are citizens of 3 sovereign governments: their tribe, the state in which they're located, and the U.S. And the reason that I mention tribes is because The importance of a state government is obvious. We're all residents of states, and we expect that state to perform certain services, like fixing bridges and highways. The importance of tribal governments is much less obvious to Americans who live in cities or suburban areas. But many non-Native Americans rely on tribal government services. In a lot of rural portions of the U.S., tribal governments are the only governmental presence for both Native and non-Native communities, and they provide really vital first responder services. So the Indian Self-Determination and Education Assistance Act, that increased tribal control over the administration of reservations. And it allows the federal government to rely on tribal governments to protect and serve both Native Americans and non-natives in rural areas. Additionally, Native American tribes do play an important role in many of our cultural movements, including the environmental movement. I've got up here a 1971 PSA for the anti-litter organization Keep America Beautiful. It supposedly starred Iron Eyes Cody. He's a Native American who sheds a tear when he's looking at all this terrible pollution of the modern world. Ironically, Iron Eyes Cody was actually an Italian-American actor, and Keep America Beautiful was founded by beverage and packaging companies in response to the first Earth Day. But even so, Native Americans have led the way on many of our environmental issues, including the Standing Rock tribal protests over the Dakota Access Pipeline. That drew a lot of national and international attention. So we have a nation that's comprised of multiple sovereign governments. We got the feds, the 50 states, Puerto Rico, DC, and 573 federally recognized Indian tribes. So how do they share power? There are exclusively federal powers. They are enumerated by the Constitution, and that includes foreign affairs, immigration, bankruptcy, which most people don't realize is a federal issue, and running the Postal Service. There are also concurrent powers, taxation, road work, controlling banks, and criminal punishment. Those are powers held by both the federal and state governments. Now, according to our Constitution, powers not assigned to the federal government are left to the states. And so we also have exclusively state powers, such as education, licensing, and police powers. Police powers is a very broad term. It does not just mean law enforcement. It is public health and welfare services. So there are exclusive powers, there are concurrent powers, there's this overlap. So the same action might constitute both a state and a federal crime. The defendant can stand trial in both a state and a federal court and be punished for both. And then for oversight, federal agencies like the National Institute of Health or the Centers for Disease Control, they provide assistance to states. They make sure that states have enacted certain plans, including the emergency response plans noted on the previous slide. At the federal level, Congress must have constitutional authority to pass laws, which is why if you look through the notes section of various statutes, and we will talk about it next week, you will find reference to parts of the Constitution. This is Congress's way of showing that it is operating under properly granted authority. Now, you may remember when the Tea Party movement first sprang into existence in the US back in the late aughts. And members of the Tea Party talked a lot about how Congress never told the American people why it had authority to pass laws. That allegation is simply untrue. Congress has always been required to explain its authority. It does so in every piece of legislation. It's just that most people, because they're not lawyers or constitutional scholars, don't know where to find that information. You'll know after next week. So anytime Congress passes a law, it has to do so pursuant to its constitutional authority. And there are three main grants of authority: the Necessary and Proper Clause, the Supremacy Clause, and the Commerce Clause. And for a very long time, Congress was able to rely on the Commerce Clause as the source of authority for many sweeping laws. And to an extent, it still does, but there's a lot more scrutiny over that than there was in the past. So the reason that we have the Commerce Clause is because when our government began, the federal government was much weaker than it is today. Prior to the Constitution, as you may know, we had the Articles of Confederation, and they specifically created a weak national government and strong state governments. Good in theory, did not work in practice. It became obvious that we needed a stronger federal government. And so when the framers drafted the Constitution, they included the Commerce Clause. And that has been the major source of Congress's lawmaking authority throughout American history, and most especially since the mid-1900s. For instance, the New Deal, which I talked about last week, that was a series of programs, public work projects, financial reforms, and regulations that were enacted by President Franklin D. Roosevelt to provide relief, reform, and recovery from the Great Depression. Now, I say enacted by Roosevelt, but really Congress passed most of these laws, and the executive branch agencies carried them out. The Constitution also has the Necessary and Proper Clause, which says that Congress can enact all laws that are necessary and proper to carry out the powers granted to it by the Constitution. And it has the Supremacy Clause, which states that the Constitution is the ultimate law of the land. So because of that, the Supremacy Clause, stating that federal law is superior to state laws, as the federal government has grown, the powers granted to Congress by the Supremacy Clause have moved our country to more of a hierarchical federal system. So more power to the feds, less to the states. And as I said last week, as people became more interdependent on each other for food and clothing, cars, healthcare, technology, all these different aspects of life, our bureaucratic infrastructure had to expand. The federal government has been growing since the start of our nation, but that growth really rapidly increased since the start of the 20th century. A lot of the growth that our country experienced after the Great Depression and after the World Wars really relied on the Commerce Clause. The New Deal relied on the Commerce Clause to revive the economy and to handle social issues. And while implementing the various statutes that make up the New Deal, Congress created many of the federal agencies that we take for granted today. Now, it is not just the federal government that has grown. State bureaucracies have also expanded, both to address more localized issues or to address larger issues where the states feel that the federal government has not appropriately responded. One example is California, which sets higher fuel economy standards for cars. That is California's effort to create more efficient cars across the whole country. California knows that its market is large enough that manufacturers are going to take notice, and they will begin increasing fuel efficiency even without a federal requirement to do so. That gets litigated a lot. It's been in the news lately. I'm sure that it'll be in the news again, sort of this struggle for power over fuel efficiency standards between California and the federal government. A more recent example is the Multi-State Compact for COVID-19. So that is an agreement between Maryland, Massachusetts, Michigan, Louisiana, North Carolina, Ohio, and Virginia to battle COVID-19. So in the absence of a federal or national testing strategy, the governors of these 7 states, 3 of them are Republican and 4 Democrats, they have formed this purchasing compact, and they are hoping that, much like California's fuel efficiency rules, they're hoping to pressure companies that make rapid detection COVID-19 tests to quickly ramp up production. All right, let's talk briefly about the history of the Commerce Clause, given its importance to our history and to our bureaucracy. So like I said, for a long time, Congress used the Commerce Clause to pass basically any law that it wanted to. And again, the reason that we've got the Commerce Clause is because prior to the Constitution, when we were operating under the Articles of Confederation, states engaged in a lot of protective measures. They wanted to protect their citizens. They tended to discriminate against citizens and businesses of other states. So under the Articles, we're really operating like many, many countries rather than one united country. As an example, Massachusetts might impose a 50% tax on any goods coming from New York because Massachusetts wanted to support Massachusetts businesses. So the Commerce Clause put an end to that sort of state versus state discrimination, and it allowed for a better flow of commerce across the nation. So the clause began to gather steam under the New Deal because we needed a lot more federal authority to counteract economic devastation and other problems caused by the Depression, World War I, and World War II. Much later, in the 1960s, the Commerce Clause also served as the basis for almost all of our civil rights laws. So the Commerce Clause has done us a lot of good, but Congress would often just make a blind reference to the clause and didn't really think about whether the law impacted interstate commerce. I think this is more of what the Tea Party was trying to get at when they were concerned about Congress not stating its authority. So nearly 30 years ago, that Commerce Clause pendulum, how the courts looked at it, it started to swing back to limit Congress's authority to use the Commerce Clause. Courts have been scrutinizing Congress's claim of Commerce Clause authority, and they've been requiring that Congress show an actual impact on interstate commerce, not just some sort of theoretical impact. So to understand that, we have to understand what counts as interstate commerce. I mean, clearly it is commerce between two or more states, but it's broader than that, because the Commerce Clause allows Congress to regulate the channels and instrumentalities of interstate commerce. All right, so what's a channel of interstate commerce? Those include navigable waterways, airspace, highways, railroad tracks, and now telephone lines and the internet, because these are conduits through which commerce travels between the states. All right, so that's a channel. What is an instrumentality of interstate commerce? These are the means used to transport goods and persons. So railroad cars, buses, trucks, airplanes, boats. The line between a channel and an instrumentality is somewhat unclear at times, but that's really of no practical consequence because the court's analysis is the same for both of them. So there are limits on the Commerce Clause, and they usually deal with the difference between an issue that is truly national and one that is truly local. If it's a truly national issue, Congress can legislate, and Congress can force the states to basically do its bidding. But if it's a truly local issue, Congress doesn't have any authority to order the states around. So this pendulum of Commerce Clause jurisprudence, that's what the courts say, so it began to swing back to the states in 1992 with the case of City of New York versus United States. That was about how the government can dispose of radioactive waste. And in that case, the federal government attempted to force the government of New York City to carry out this federal radioactive waste disposal program. New York City was not too keen on the idea of babysitting a bunch of radioactive waste, and so it sued the federal government. And the Supreme Court agreed with New York that the feds cannot force states to carry out federal programs when all of the activity was occurring within a single state's borders. In 1995, in U.S. v. Lopez, the Supreme Court struck down the Gun-Free School Zones Act. Not because the court wanted school kids packing heat, but because Congress did not provide a sufficient reason as to why it was authorized to legislate the activities of public schools, which are historically local government bodies. Now, Congress claimed that the possession of a gun in a public school would probably lead to violent crime, and an uptick in violent crime would probably affect the economy because insurance costs would go up, or people would be scared to travel through and thus spend money in unsafe areas. There were a lot of likely and probablys and maybes in there, and so the court did not buy that argument with regard to congressional authority. Now, research has shown that yes, violent crime does impact the surrounding area, and the court recognized that, but the court held that gun violence does not impact interstate commerce, and so Congress can't use the Commerce Clause to essentially regulate state and local public school systems. Those belong within the province of state and local governments. Supreme Court continued to limit Congress's power under the Commerce Clause, really right up until the turn of the new century. It struck down certain requirements of the Brady Bill. That was passed after then White House Press Secretary James Brady was shot and wounded during the attempted assassination of President Ronald Reagan back in March of 1981. So Congress passed the Brady Bill. Clinton signed it into law. And so in Prince versus United States in '97, the court ruled that state and local police could not be forced to carry out federal background checks for handgun purchases. The court basically said, Congress, you cannot press state and local police into federal service. And this is actually something that is important now because it's the reason why our local police departments do not have to enforce federal immigration law. Then in 2000, in the case of U.S. versus Morrison, the Supreme Court invalidated part of the Violence Against Women Act. It ruled that Congress can't regulate non-economic violent criminal conduct based on the Commerce Clause. Basically, it said, Congress, there's standard crimes being committed within the states. You can't use your Commerce Clause authority to get to that. Now, if violent crime is, economic and the criminals are operating in multiple states, then the federal government can become involved. And that's why federal agents are often the ones who bring down mafia bosses and otherwise use the Racketeer Influenced and Corrupt Organizations Act, or RICO, to break up organized crime. Now, there are these restrictions that the courts have placed on Commerce Clause authority, but keep in mind that Congress can also get around these restrictions, usually by attaching conditions to appropriations. So, for instance, states have to keep the drinking age at 21 in order to receive federal highway funds. So if Congress isn't allowed to use the Commerce Clause to get its way, it can sometimes instead rely on the power of the purse. Now, recently, there has been some expansion of federal power via the Commerce Clause for activities that don't obviously impact interstate commerce, but the courts have held that there is an impact. So one particularly odd case involved the regulation of some kitty cats. The 11th Circuit Court found that the descendants of Ernest Hemingway's six-toed cat, Snowball, all these kitty cat descendants, live at his museum home in Florida. And the courts held that those cats are subject to federal regulation because they substantially affect interstate commerce. And that's because the Hemingway Museum in Florida advertises those six-toed cats as a reason for out-of-state residents to visit Florida. So it is targeting non-Floridians to bring them into Florida to spend money. This case came up because a museum visitor filed a complaint with the USDA over the treatment of cats. The visitor did not think that the museum was treating them appropriately, and as we learned, the USDA is the agency that gets to regulate how people treat animals. So, the visitor files with the USDA, this becomes a federal case, and a federal court ruled that yes, the USDA can indeed regulate the cats at the Hemingway Museum because they are used to drum up interstate commerce by bringing in tourists from other states into Florida. There have been other cases that have expanded Commerce Clause power. One of them, also in our book, is Gonzales v. Oregon. And what's important here is the preemption doctrine, which we're going to talk about in just a minute. So Gonzales v. Oregon was about the state of Oregon's Death with Dignity Act. And the federal attorney general did not like that and issued a rule, a regulation, stating that assisted suicide is not a legitimate medical practice, even though an Oregon law held otherwise. And in this case, the Supreme Court said, look, the Controlled Substances Act, it authorizes the federal government to regulate certain drugs, but it does not authorize the feds to regulate the practice of medicine within the states. That is a historically, traditionally state power. And one of the key parts of this case that the textbook does not really get into is that Congress very clearly did not intend to preempt state law. You know, if Congress preempts state law, it's going to do so fairly explicitly. And the Controlled Substances Act actually has this provision that it is not intended to preempt valid state law. So speaking of preemption, we have the preemption doctrine. It is a constitutional principle derived from the Supremacy Clause. So remember that sometimes federal and state governments have concurrent jurisdiction over a certain subject matter. The preemption doctrine allows the federal government to come in and exclusively control what used to be controlled by both the feds and the states. So as an example, we've got the Voting Rights Act of 1965. It preempted voting restrictions in state constitutions. A lot of state constitutions at the time had measures that were intended to keep primarily Black Americans from being able to vote, like a poll tax or a literacy test, or they'd have to do something ridiculous like properly guess the number of marbles in a jar. So the Voting Rights Act preempted all of that. It said, yes, states, normally you are indeed in charge of your elections, but in this case, Congress is explicitly letting you know that federal law is going to apply. So the federal government can exclude state laws and regulations where Congress specifically says so in a statute, where state law is clearly inconsistent with federal law, or where there is a comprehensive scheme of regulation. So for instance, pharmaceutical drugs, Nuclear Regulatory Commission activities. There's a comprehensive scheme. And so preemption applies. It doesn't have to apply though. For instance, Colorado, California, and other states have medical and recreational marijuana laws. Those are in direct conflict with the Controlled Substances Act, but the federal government has generally decided to leave the states alone and let them try to carry out this little experiment in democracy. Okay, so that's federalism, the division of power between two or more sovereigns. The doctrine of separation of powers is the division of power within a single sovereign government. So the intent is to create a system of checks and balances so that no branch of the government can dominate the other branches. So well-known example, courts get to review Congress's exercise of authority and determine if Congress has overstepped its bounds. Another example is that Congress passes laws, but the president, who heads the executive branch, has to sign those laws before they can take effect. Less well-known is the idea that one branch of government may not exercise the authority that is granted to another branch. So the president can't interpret the law to resolve a dispute between a company and a federal agency because that is left to the judicial branch. And the judicial branch cannot create laws. That is left to the legislative branch. Now, we will learn later the judicial branch does create common law. That is judge-made law that operates where there is no legislation covering a particular situation. But the legislature, if they're not happy with the common law, can pass a statute and override it. Agencies create a pretty unique situation for the concept of separation of powers, and that's because they exercise functions of all three branches of government. As part of the executive branch, agencies are exercising the executive function of implementing and enforcing laws. That makes sense. That's what the executive branch is supposed to do. But Congress has also delegated agencies some legislative authority and some judicial authority. So on the legislative side, agencies are allowed to create regulations. And these regulations fill the gaps left by Congress when it enacts laws. So statutes are broad, regulations are more narrow. They're there to gap fill the statutes. And those regulations have the force of law. So agencies do get to have this quasi-legislative authority. Now, Congress, of course, retains the bulk of it. And as we'll learn later, Congress can basically veto agency regulations as long as it does so quickly and in the right way. So for instance, got the case of INS versus Chatta. The court struck down the idea that a single house of Congress could overturn an agency regulation. Congress was not happy about that. So to clarify its ability to address these agency regulations that it doesn't like, Congress passed the Congressional Review Act. And that specifically allows Congress to review and overturn agency regulations. It has to do so, though, with a vote of both the House and Senate, and within a certain amount of time. So Congress has to move quickly. Because of the unique role of agencies, we, the people, should be concerned about the lack of separation of powers within agencies. The absence of this doctrine can leave agencies without effective oversight, especially if they are independent agencies. So it can increase independence and it can decrease agency accountability. So we think of agencies as being accountable to the executive, to the president. And it's sort of common sense that if you're the boss, you've got to be able to control your employees. It's not that simple, though, when it comes to presidential authority over federal agencies. The president does exert control over most executive branch agencies, but it is not a complete control. And that's because agencies themselves are intentionally a bit removed from politics, and the civil servants who staff those agencies are entirely removed from politics due to the Pendleton Act. The president also lacks the power of the purse. It's Congress that holds the purse strings for those agencies. So Congress creates an agency, and then it places that agency in the executive branch, but slightly removed from politics, and thus somewhat exempt from presidential control. Kind of a unique method of creating a government function. And that is why agencies are somewhat unique, and we've got this whole class about them. But let's say that didn't happen. Let's say agencies weren't created by Congress. Let's say that they didn't have their powers and budgets defined by Congress. Even if they were totally under the control of the executive branch, it would still be challenging for the president to directly control the federal bureaucracy because of its sheer size. Another factor to consider is the idea of superior and inferior officers, so the heads of departments and agencies. So think back to Constitution, Article 2. That grants the president a role in appointing agency personnel, specifically the principal officers of executive departments. These officers are nominated by the president with the advice and consent of the Senate. Basically, that means the president gets to pick the candidate, but the Senate has to confirm them. Other agency personnel might be inferior officers or simply employees. Congress can actually decide how to appoint some of those inferior officers. Now, Congress can give that responsibility to the president, to a department head. It's really up to Congress. And it's Congress that has the greatest control over agencies. It creates them, it reorganizes them, it disbands them, it establishes their budget. Congress passes statutes that tell agencies what to do, so it sets their policy objectives. And Congress also engages in oversight of agencies via congressional committees. For a long time, though, political and practical reasons kind of kept Congress from flexing its muscles when it comes to exercising control over agencies. Politically, members of Congress liked to insulate themselves from criticism by instead pointing to agency officials. So the idea was, there's an unpopular regulation. Well, the buck doesn't stop with Congress. It's like a hot potato that Congress chucks over to the agency. In part, this is changing because, well, Washington has been consumed with partisanship for a while now. And so Congress has occasionally become more willing to control agencies, especially if Congress is held by one party and the presidency is held by the other. So in the case of the Consumer Financial Protection Bureau, that was created during the Obama administration, but the GOP-controlled Congress really wanted to weaken the agency. So it at first insisted that Congress control the CFPB's funding. This is actually pretty rare. While Congress does control funding for many agencies, in the history of the United States, no banking regulator had been funded by Congress. A lot of regulatory agencies cover their costs directly or indirectly through fees. And in part, the fees imposed on the regulated entities, so banking fees, etc. And that's supposed to keep regulators safe from political pressure. So Congress instead wanted to control the CFPB's funding in order to weaken the agency's powers oversight. That did not entirely happen, however. Congress can also weaken an agency or committee by limiting its duties. We'll read about that in A Fighting Chance with the Congressional Oversight Panel for the Troubled Asset Relief Program, or TARP. In that case, that panel was only given the power to write reports. It couldn't subpoena information, it couldn't take testimony. So that was one way that Congress was controlling the bureaucracy. And again, Congress can also control the bureaucracy via the Congressional Review Act, which allows Congress to overturn agency regulations as long as Congress does so within 60 legislative days of that regulation. We'll talk about that more later. Things are a little bit different for independent agencies. Federal independent agencies, they exist outside of the federal executive branch's direct control. So usually when we talk about an independent agency, we are describing agencies that are constitutionally part of the executive branch, but the president does not control them, primarily because the president's power to dismiss the agency head or a member of the agency's governing board is limited. So to put it another way, these independent agencies are part of the executive branch, but they are not part of one of the 15 cabinet-level executive departments. So most executive branch agencies, well, the departments have a single secretary, and then agencies usually have an administrator, a director, and these people are appointed by the president and confirmed by the Senate. Independent agencies, on the other hand, are most often headed by a commission, a board, or a similar group of 5 to 7 members. And that is why so many independent agencies have the word commission or board in their name. Now, while most independent agencies are headed by multiple commissioners, some are not. For instance, the CIA, National Science Foundation, EPA, NASA, and GSA, these are all independent agencies that are headed by a single individual, a director for the CIA and NSF, and an administrator for the EPA, NASA, and the GSA. The president appoints the heads of independent agencies, be they multiple commissioners or a single director or administrator, and that's subject to Senate confirmation. So that part is normal. But these independent agency heads often serve terms that are staggered and more than 4 years. And so that means that most presidents don't have the opportunity to appoint every single commissioner in a given independent agency. There are also statutory provisions that limit the president's authority to remove commissioners and other heads of independent agencies. Typically, the president can only remove them if they're incapacitated, neglecting their duty, or they're doing the wrong thing, or some other good cause. In addition, a lot of these agencies actually have a requirement of bipartisan membership. So a president can't fill vacancies necessarily with members of his own political party. And additionally, sometimes Congress actually requires specific subject matter expertise for the heads of those independent agencies. But because most of these agencies, these independent agencies, they exercise executive power, like enforcement of laws and regulations, Congress is not authorized to involve itself in the removal of agency directors or commissioners. If Congress doesn't like it, Congress can't simply remove them. But Congress can pass laws that limit the circumstances under which the president can remove the heads of independent agencies. So there has been quite a struggle between Congress and the president when it comes to removing agency officials, particularly independent agency officials. There was the 1926 Supreme Court case, Myers versus United States. And there, the court invalidated an 1876 law that required the president to get the Senate's approval to fire postmasters. And this decision in Myers was generally taken to mean that Congress could not interject itself, as the legislative branch, into executive functions. The decision at the time, it was written by Chief Justice Taft. He noted that the Constitution mentions the appointment of officials, but is silent as to their removal. And examining the notes of the Constitutional Convention, so far as Chief Justice Taft was concerned, showed that that silence was intentional. The convention did discuss dismissing executive branch staff and kind of believed that it was sort of implicit in the Constitution that the president held that authority because that staff is sort of an extension of the president's own authority. In 1935, the Supreme Court's decision in a case called Humphrey's Executor changed this viewpoint to a degree. In that case, the Supreme Court upheld a law that limited the president's ability to remove FTC commissioners by requiring good cause for removal, rather than the at-will removal permitted in the Myers case. In Humphrey's Executor, what the court tried to do was clarify that the nature of the executive officer position is critical. If you have a purely executive official, they're carrying out the law, but they're not making policy, they're not performing judicial functions, then the president can remove them at will. And oftentimes that means for political reasons. But if you've got executive officer positions like the FTC commissioners that can hear disputes and that can issue regulations, so in addition to wielding executive power, the FTC has this quasi-legislative and quasi-judicial power. Because of that, Congress is able to limit the authority of the president to remove FTC commissioners. So, nature of the position, purely executive, president gets to do what he wants. Executive plus quasi-legislative or quasi-judicial, Congress is able to limit the authority of the president to removing these people for good cause. Now, in 1988, there was another shift in thinking. And in Morrison v. Olson, the Supreme Court upheld the Independent Counsel Act. That act limited the authority of a president to remove the independent counsel, who is a purely executive official. And the reason that it was okay for Congress to limit the president's authority was that while the president couldn't remove the independent counsel, the Attorney General could. And the Attorney General is also an executive officer who reports up to the president. So the president can remove the Attorney General, who can remove the independent counsel. So Morrison v. Olson shifted the focus from the type of functions that the executive official is performing, executive, legislative, judicial, to whether Congress has impaired the ability of the president to perform constitutional executive functions, or whether Congress has improperly delegated some of those executive functions to itself. And this struggle continues. In the 2010 case of the Free Enterprise Fund versus Public Corporation Accounting Oversight Board, the Supreme Court, held that the method through which members of that board are removed violated the separation of powers. So that board supervises compliance with the Sarbanes-Oxley Act. And board officials could only be removed for good cause, and they could only be removed by officers of the Securities and Exchange Commission. Those SEC officers could be removed by the president, but only for good cause. So there was what the court called a dual for-cause limitation. So if you look at the independent counsel, the president can remove the attorney general at will. The attorney general could only remove the independent counsel for cause, but we're still within the line of chain of command for the president. For this Free Enterprise Fund case, that board was really outside of the president's control. The president was restricted in his ability to remove an SEC officer, had to be for good cause. That SEC officer was in turn restricted in his or her ability to remove an inferior officer, one of these board members. And that's even though the inferior officer was determining policy and enforcing laws. So Congress's attempt to limit the president's Article II authority in this particular case, the authority to oversee the executive branch, the court held that this violates the Constitution's separation of powers doctrine. So with all this in mind, let's turn to the creation of the Consumer Financial Protection Bureau, or CFPB, or as I will no doubt misstate it, CFBP. So you're going to read about the CFPB in much more detail in A Fighting Chance, but I'm going to provide the broad strokes here. So after the 2008 financial crisis, which stemmed in part from excessive risk-taking by banks, which were offering a super confusing array of complicated mortgages and mortgage-backed securities, the Dodd-Frank Wall Street Reform and Consumer Protection Act, which is generally known as Dodd-Frank, created the Consumer Financial Protection Bureau to protect consumer interests in the financial sector. So Congress created the Bureau as an independent agency located inside of and funded by the U.S. Federal Reserve. So again, this means that the Consumer Financial Protection Bureau has funds to operate regardless of congressional appropriations. Dodd-Frank gave the CFBP jurisdiction over banks, credit unions, security firms, payday lenders, mortgage servicers, foreclosure relief servicers, debt collectors, and other financial companies. Basically, all the people who were naughty and caused the 2008 financial crisis. You can see here that Title 10, Subtitle A of Dodd-Frank creates the CFBP. Subtitle B grants the Bureau general agency powers. For instance, it can issue regulations through the rulemaking process that we'll discuss in a few weeks. And Subtitle C grants the CFBP specific authority to prohibit the types of financial practices and behaviors that harm consumers. Subtitles D through H focus specifically on protecting consumers throughout the house purchasing process. Because the subprime mortgage crisis played such a large role in the overall 2008 financial crisis, Congress really wanted the Consumer Financial Protection Bureau to help Americans navigate the complicated process of buying a house, and wanted the Bureau to regulate certain aspects of home mortgages in order to protect homeowners and tenants during foreclosure proceedings. Between 2011 and 2017, the Consumer Financial Protection Bureau has curtailed a bunch of abusive debt collection practices. It has somewhat reformed mortgage lending. It has investigated hundreds of thousands of complaints from American consumers. And it's gotten about $12 billion in refunds and canceled debts for about 30 million Americans. Now, the 2008 financial crisis is not well understood by the average American, and in part, that's because banks and hedge funds intentionally created really complicated financial vehicles. So if you want to understand how so many individual homeowners got swept up and lost so much in that crisis, I recommend another Michael Lewis book. I promise you I get no money for recommending these, but his book, The Big Short, does a really, really good job of explaining the 2008 financial crisis, particularly subprime mortgages. The movie version, The Big Short, is also pretty good if you've only got a couple hours. Now, the Consumer Financial Protection Bureau's status as an independent agency has been subject to many, many challenges in court, including direct challenges to its constitutionality. Both Elizabeth Warren and President Obama originally proposed that the CFPB would be a traditional multi-member independent agency, so very much like the FCC or the FTC. Congress, though, changed course, and it created an independent agency headed by a single director. That director is appointed by the president and confirmed by the Senate. Congress also restricted the president's ability to remove the CFPB director. That director is not an at-will appointee whom the president can remove for political reasons. That director can only be removed for cause. And while not shown on this slide, the director's term is 5 years. So again, the director can serve beyond the term of a presidential administration. And we will learn more about the various challenges to the Consumer Financial Protection Bureau as we progress through the semester. Spoiler alert, though, in June 2020, the Supreme Court did hold that this single director structure with the director removable only for cause was unconstitutional. But the court did not hold that the Consumer Financial Protection Bureau itself is unconstitutional, so the agency remains in operation. And that is what we'll talk about throughout the course. All right, so where are we now in terms of agency oversight and control? For decades, presidents had the desire, but not necessarily the authority to control agencies. This has changed rather drastically and suddenly with the Trump administration, because President Trump has tried to exert and frequently has exerted a lot more control over the bureaucracy, in part by relying on interim or acting agency heads who do not require Senate confirmation. Now, it is not unusual to have acting officials. All presidential administrations have acting officials at times, but the Trump administration has been really extreme in its use of acting officials and its inability to properly fill some important vacancies, including vacancies at agencies that should be providing a response to COVID-19. So Trump has really used these interim or acting officials to circumvent the Senate confirmation process. He installs political appointees in these interim positions and then just kind of leaves them there without a formal nomination, without formal backing of the Senate. That is problematic from a constitutional perspective. It is also problematic from a practical perspective because acting officials are temporary by nature. They don't have the authority to set or implement policies. That's not to say that they don't try to, because they do, but they're not authorized to. A lot of times they don't even know, much about their agency, don't have time to learn the ropes of their agency because they are limited by statute to a 220-day period, at which point they are no longer acting directors or interim heads. They are simply senior officials. We have really seen cycle through the Trump administration acting officials with very, very limited experience. You can take a look too at the news item that I posted in our classroom. the GAO has recently rebuked the Trump administration for its use of acting officials within the Department of Homeland Security. Now, unlike presidents, Congress has almost always had the authority, but not always the desire to control agencies. Historically speaking, Congress has really relinquished its oversight in favor of waiting for judicial review. As we'll learn later, though, judicial review can take years and years. Lately, though, we do have members of Congress who seem awfully interested in dismantling the bureaucracy, even if they have no real idea of what the bureaucracy does for the nation or the critical importance it plays. For instance, when Rick Perry wanted to abolish the Department of Energy because he thought it didn't do anything, it in fact does a whole lot, including running our nuclear program. Other members of Congress have taken a keen interest in protecting agency operations, like we've recently seen with the Democrats' focus on the U.S. Postal Service. And again, like I said, the GAO, which is a legislative branch agency, so the GAO reports to Congress. It provides auditing, evaluation, and investigative services, and the GAO's focus is on accountability, integrity, and reliability. And so it has started to weigh in on the appropriateness of having acting officials in charge of federal executive agencies. All right, that is it for this week's lecture. There is a discussion due, so please be sure to post on discussion board 1, Getting to Know You. Next week, we are going to take a look at legal research. Fear not, it is specifically for non-lawyers, so I'm not expecting you to be a lawyer. So thank you for listening. Hope you have a good week. I will see you on the discussion boards.